So State, do you want to have all of the defendants, the remaining co-defendants, make their argument and then respond to all of them, or you want to do it one by one?
Judge, I prefer to do one by one.
Okay, that's fine. So it seems to me, before you get going, that what this really comes down to, and the case law is articulated, the precedent, the binding precedent, is articulated pretty clearly in the McCrae case, McCrae versus State at 416 Southern 2nd 804. And that was a Florida Supreme Court opinion, and they stated as follows. The object of the rule is not to provide defendants with an absolute right upon request to separate trials when they blame each other for the crime. Rather, the rule is designed to assure a fair determination of each defendant's guilt or innocence. This fair determination may be achieved when all the relevant evidence regarding the criminal offense is presented in such a manner that the jury can distinguish the evidence related to each defendant's acts, conduct, and statements, and can then apply the law intelligently and without confusion to determine the individual defendant's guilt or innocence. The rule allows the trial court, in its discretion, to grant severance when the jury could be confused or improperly influenced by evidence which applies to only one of several defendants. A type of evidence that can cause confusion is the confession of a defendant which by implication affects a co-defendant, but which the jury is supposed to consider only as to the confessing defendant and not as to the others. A severance is always required in this circumstance. In situations less obviously prejudicial than the Bruton circumstance, the question of whether severance should be granted must necessarily be answered on a case-by-case basis. Some general rules, however, have established, specifically the fact that the defendant might have a better chance of acquittal or a strategic advantage if tried separately does not establish the right to a severance, nor is hostility among defendants or an attempt by one defendant to escape punishment by throwing the blame on a co-defendant a sufficient reason by itself to require severance. If the defendants engage in a swearing match as to who did what, the jury should resolve the conflicts and determine the truth of the matter. None of the co-defendants in this case, the Hunter case, made a Bruton-type confession, and the evidence presented was not so complex that the jury would be confused by it and incapable of applying it to the conduct of each individual defendant. So that would be kind of juxtaposed to the Hernandez case, which we've already discussed pretty extensively. The Hernandez case, as we discussed, had to deal with the co-defendant brothers' prior drug transactions coming in during the middle of the trial. The other case would be the Miller case, which I think some of you cited too, 756 Southern 2nd, 1072. It's a 4th DCA opinion. And in that case, one of the co-defendants had contacted the victim and apologized and also offered to pay the victim money to not proceed forward with charges. And in that case, even though it was not per se Bruton, the 4th DCA held that the acknowledgement of guilt by appellant's brother through his apology to the victim, that's another brother case actually, by appellant's brother through his apology to the victim and the offer to pay him to drop the charges undermined both defendants' theory of self-defense. Okay, so I guess just to start off, just to confirm with the state, you're not going to seek to admit these post-homicide statements by an inmate, Shane Payne, these are intercepted phone calls to Tayshawn Schatz Thomas, or a phone call to LaShawn Walcott, correct?
That is correct, Your Honor.
Okay, so we don't need to worry about that. So my next question would be to you, would be, as far as statements go, the celebratory statements made by Davion Murphy. These would be 2 messages sent from Mr. Gathwright's phone between 12:58 p.m. and 1:01 p.m. on June 23rd, 2024, hours after Mr. Jones's homicide. And the first message is, "I'm coming home, my thirst is quenched, pop a bottle of Don Julio today, Murphy." The second message is, "I'm coming home, my thirst is quenched, I love you, Murphy." All right, so it's not Bruton, but do we start to cross over into being a Hernandez or Miller issue?
Judge, I do not believe so, Judge. I believe that again, that's direct evidence against Mr. Murphy, and that is also inextricably intertwined evidence and gang evidence, Judge. And I do agree with McCrae that situation's less prejudicial than Bruton is a case-by-case basis, but I still think that the court is on firm ground and not severing these defendants. And when you look at Victorino and you look at Hunter, those were death penalty cases where you had multiple 3 defendants. And when you talk about being complicated, that case, they had 6 murder victims, as well as it was, I believe, a 19-count indictment. So there were many more charges in that case. And this is not a RICO-type situation where jurors are gonna have to be looking at Excel spreadsheets and sifting through that type of complicated evidence. This is a simple and straightforward gang rival case, Judge. And when you're looking at Victorino and Hunter, those are Florida Supreme Court cases, and in those cases, defendants were asking to sever out, and the trial courts denied those motions to sever, and those were both upheld by the Florida Supreme Court. And likewise, in this case, we have not 3, we have 4. There are no Bruton issues which would require severance. And when you talk about, and the only reason why we went into the litany of factors, you, Judge, you sat in on the motion for pretrial defense, for pretrial detention for Rashad Murphy, and that same litany of facts going into the rival gang, as well as all of the things that the co-defendants, every defendant in this case did, was relevant, because this is a case where it was a group crime. They are charged as principals, and they are going to be held responsible for every action that their co-defendant did, because we can prove and show that they all intended for the crime to be committed, and they all did some act and participated into this crime. So when we talk about overlapping evidence, and Your Honor, you presided over one of the co-defendants that was severed out, this wasn't a case where only the evidence was admitted only as to what Ms. Andrews did. All of the evidence of all of the co-defendants was admitted. So when we talk about the evidence, with all due respect to Mr. Gonzalez, all of that evidence, all of the ballistic evidence, all of that evidence is going to come into evidence against Rashad Murphy, just like it will against Isaiah Chance, Sean Gathright, and Davion Murphy. And why we put in all of that facts into every single response, into the pretrial detention motion, is because they are charged as principals. So when we go back to the issue of severance, and when we talk about Hunter, the second DCA case, Judge, I think was the best argument for the defense, where
Hernandez.
What did I say, Fernandez?
You said Hunter, but it's Hernandez.
The Hernandez, the second DCA case, where they severed it out. And what was key in that Hernandez case was, that it was so prejudicial, was that the evidence that was admissible against his co-defendant, the co-defendant brother,
Right.
would not be independently admissible in his own trial.
Well, isn't that really the crux, though, of the whole issue?
Yes.
Is that I would have to find that there is evidence the state is seeking to admit that would be inadmissible against the co-defendants. And the reason why I'm gonna go back to these homicide statements made by Davion Murphy. They're not co-conspirator statements, because the conspiracy's over. Mr. Jones is dead. So, and these statements did not come in, that I recollect, during the trial of the co-defendant Alicia Andrews. So, these statements, so I'm asking you, the state is seriously intending to introduce these statements or these telephone messages, these text messages, and are you telling me that if defendants Rashad Murphy, Sean Gathright, and Isaiah Chance were tried separate from Davion Murphy, would these be admissible? They don't come in a co-conspirator, so why would they be admissible against them?
Judge, I think that it is because it is inextricably intertwined. If
Yeah.
the evidence of motive is, and so that is also one of the reasons why we did provide the court with the Richardson case and all of the cases regarding to inextricably intertwined. And it's not just inextricably intertwined that that all of that evidence came in. It also came in as motive, and it came in as intent. And we are going to be able to provide evidence that this was evidence of that motive, Judge.
Yeah, I don't know. I don't know that this statement, if they're tried together, if this statement by Davion Murphy is coming in, just for that reason, just so you know. I don't think it is. So the state may have to decide what you want to do. Just throwing that out there as one example of evidence that would seem to violate the Hernandez precedent in that it is prejudicial and it's not admissible against the other co-defendants if they were tried separately. So I'm just letting you know.
Judge, I also want to talk about conspiracy and when a conspiracy ends. I know what is alleged in the indictment, but we are talking, there are two vehicles.
I know, but the conspiracy ends when Mr. Jones is dead. That's when it ends. Conspiracy's over. The object of the conspiracy has been achieved. He's dead. Because I researched this issue, so I'm very aware of the case law on it. So once Mr. Jones dies, there is no further co-conspirator admission of any statements. The conspiracy is over. So, anyway, okay, so go ahead.
Judge, going back to the question of whether or not they need to be severed out, and talking about Victorino and Hunter, again, in those cases, the trial court did not allow separation, did not find that there was anything so complicated about that evidence. And I think, Judge, that is something that is critical in this particular case. I don't think that there is anything that is so complicated about this case. And I know that Mr. Gonzalez had mentioned and was talking about the gang evidence. That type of rivalry is inextricably intertwined. Richardson is basically a primer for this case, and I do think that it is very similar. In that particular case, there were 6 other incidences of violence that came in that case to show basically, again, motive, intent, but also to show the jury an accurate depiction of the facts that were leading up to the offenses that occurred in this particular case. And when you look at the evidence that we are going to be showing, not just through gang expert testimony, we are not going to just be showing evidence through hearsay. Also listed with those gang experts in Jacksonville are first responding officers or officers that investigated each one of those incidences. So the jury is going to be able to know that those incidents really happened. And all of those incidents go to not just inextricably intertwined, but it goes to motive and intent, which was the other area why that evidence is critical in this particular case, because it shows the back and forth retaliation. And not just the back and forth retaliation, the Richardson case showed 6 prior incidents. They also showed all of the different rap videos that showed the motive. And in particular, Judge, there is going to be rap videos of Mr. Jones, the victim in this case, which clearly, again, it all goes to motive. I think Mr. Gonzalez says, like, all of this evidence wasn't going to go to motive. It clearly is going to motive. The victim in this case is known for producing these drill rap videos where he specifically is mentioning people that are associated or in the gangs that have been killed who all of the defendants know. And so it's not just the fact that you have 1200 or ATK. It is going to be clear based on the expert gang testimony that those 2 gangs are allied, and based on the video that Mr. Jones himself put on or put up on Instagram, that is the motive why all of the defendants in this particular case had a reason and did in fact want him dead. And so, Judge, going back to Hernandez and any concern about those prior instances, we believe it's the state's position that all of those instances are inextricably intertwined, as
As
well
to
as.
each defendant, right? That's what you're saying.
Yes, and that it would come in against each defendant. So there is no reason that you would need to do a severance. And when you're talking about the penalty phase, just as Your Honor said, in Victorino and in Hunter, those were death penalty cases, and there wasn't anything so complicated about that 6 first-degree homicide count, 16-count indictment, that the jurors couldn't make a distinction and separate out the evidence to each particular defendant. And that's exactly what happened in that case. There were death recommendations by the jury as to some of the defendants, and then a recommendation for life as to other. And they also made distinctions as to who should get death with regards to a specific victim. So to suggest that where we have one victim of first-degree murder, that a jury would not be able to make a distinction, Judge, we believe that those two cases clearly show that juries can do as they're instructed, and there are instructions specifically that address that concern, that they would be able to separate out the evidence and make a decision based on what evidence applied to each defendant. I know that there are 4 remaining co-defendants, but again, that does not make this case more complicated or overly confusing or complicated that a jury could not sort it out. I know Mr. Gonzalez said he is not aware or familiar with social media, but that is something that would be for the state to be able to present to a jury in a clear way. There isn't anything so complicated about 4 defendants who actively grouped together to commit this crime. And so all of the inextricably intertwined evidence that we have talked about is relevant and would come in against Mr. Murphy. And again, I do want to speak to Mr. Gonzalez said, like, one of the other considerations in McCrae and some of the considerations for severing, where you're looking at independent evidence. There is going to be independent evidence and proof of the defendant's guilt, each one of the defendant's guilt, how they are responsible and tied to this crime, including, which Mr. Gonzalez forgot to mention, the fact that the defendant is the one that actually obtains one of the suspect vehicles, the silver Chevy Cruze. We know exactly how that vehicle is obtained, and it is, again, through a connection that Mr. Murphy has, that his particular client has, that he's the one that obtains it. That vehicle is driven down to Tampa. It comes in tandem without going to all the facts that Your Honor knows. That is just one of the pieces of evidence, as well as that video footage that is similar clothing worn by that individual, and the fact that all of the crime, all of the surveillance is captured on video, that is admissible against every single one of them, and the circumstantial nature of the case and the fact that they are principals, all of that evidence is going to come in, including evidence of the defendant's gang activity, which is not just based on hearsay or word on the street. There is documentation of those acts that occurred in videos, those rap videos that we've heard about, where he actually was shown, and just because he didn't see the handshake or didn't understand the handshake, that again is for a jury to determine. But those are things that are going to come into play, and he has been certified, and I agree that the jury is going to make the decision whether or not he's a gang. But the reason why all of that is in there, and the reason why we talk about the inextricably intertwined and the motive evidence, is because that is what makes all of the evidence of those inextricably intertwined incidents admissible against each and every one of the defendants in this case, Judge. And going back to, I understand your position about the celebratory. I'll certainly talk with co-counsel about whether or not we believe we need those, or we'll make a decision about that. But that is evidence, again, that we want to come in, because there is also evidence, when we talk about the ballistics evidence in this case and the circumstantial nature of the case, the entire trip from Jacksonville and how all of the defendants get to Tampa is evidence. How both of the vehicles leave Tampa and go to Polk County and and the evidence that is uncovered there, and one of their co-defendants then immediately goes to Jacksonville in another vehicle where there is additional evidence recovered in this case, and where there is evidence that is directly linked to this defendant, all of the defendants, back in Jacksonville, and it is all of the defendants who eventually get back to Jacksonville, and all of the video surveillance evidence that shows at the Airbnb, and then at, again, co-defendant Sean Gathwright's house, which includes this defendant, along with testimony from an Uber driver that he drove and picked up the defendant from that Airbnb in Tampa back to Jacksonville, and all of the consciousness of guilt evidence when those vehicles are seized, including this particular defendant, when he is found in the very exact same suspect vehicle utilized in the hunting and killing of the victim, Mr. Jones, in this case. So we believe all of that evidence is admissible against all of the defendants, because this is a circumstantial case, and they are responsible for all of the actions that they did pursuant that assisted in this case, which included getting rid of evidence, which included removing both vehicles from Tampa to other locations where we weren't able to get them until days after the homicide was committed. So all of that evidence, we believe, should come in and shows why these cases should not be severed.
All right, well, in the way that I view this, there's two separate kind of tranches of evidence. So when we're using the term inexplicably intertwined, as my understanding is, we're talking about the pre-homicide gang violence history, and I'm assuming you would concede that if for some reason I determine that some of what the state seeks to admit as their inextricably intertwined evidence is only admissible as to some of the defendants and not others, then we've got a severance issue, correct?
Yes, Your Honor.
Okay, so if I find that all of the proffered evidence, or if I say to you, listen, I believe that this is the proffered evidence that would be applicable and would be inextricably intertwined as to all defendants, then we don't have a severance issue as far as that goes, right?
Yes.
Okay, and then we have this separate issue of evidence that would be admissible as part of either the conspiracy or as principles or as direct evidence, right? That's a separate tranche of evidence, so to speak, right?
Yes, Your Honor.
Okay. And then that would require kind of the same analysis. Is there any of that evidence that would be inadmissible as to one of these defendants if they were tried separately? That's what my inquiry needs to be, correct?
I agree, Judge, but
Okay.
I also think that because it is a principal case, that evidence would be admissible
I
in
know.
their trial.
I'm not saying it is or isn't. I'm just trying to lay the framework.
distinction.
Yeah,
Okay.
make the distinction between the gang history inexplicably intertwined, evidence going to potential motive versus actual evidence that was part of the conspiracy and as principles to the offense. So, okay. Okay, very good. Thank you. Thank you, Mr. Wise. So State, what is your response to that on, it is on page 5 of 20 of the state's response, talking about it, because I don't recall this, did this come in the Andrews trial?
Judge, I don't believe that it came in the Andrews trial, but Judge, that there is evidence of that conversation, and the defendant, Mr. Gathright, does respond, and this occurs before the offense when Isaiah Chance is in a conversation with the victim discussing the fact that he was shot in the foot before, and there is direct evidence tying Mr. Gathright and Mr. Chance to that October 7th motive evidence where the victim was shot in the foot. And so, Judge, there is dialogue from Mr. Gathwright's phone where he and Rashad Murphy are then discussing, because that is a social media site on Twitter that anybody can watch. So as that is going on, you immediately have this conversation by the defendant. It predates the offense, so certainly that qualifies as a co-conspirator statement, Judge.
And just so I'm clear, so there is this Spaces video chat room on X on June 6 of 2024, correct?
Yes, Your Honor.
In which Isaiah Chance has asked Mr. Jones, "Hey Foolio, your foot okay, cuh?" And I guess he also states that he's got bigger fish to fry. And then on that same day, as Mr. Chance and Mr. Jones are arguing on this social media platform, defendant Rashad Murphy is texting the co-defendant, Mr. Gathright, and Rashad Murphy instructs Gathright to make sure that Mr. Chance doesn't ruin the plan, letting them get him worked up because they have bigger things to tend to.
It says
Okay.
bigger shit to tend to verbatim, Judge.
Okay.
And some
Okay.
other cuss words. And then there is a response where you can like that, so Mr. Gathright likes that statement, and then he responds, "Ain't heard from bro, TD, but I'ma check it with So there is directly a response, and then there's another response from Mr. Murphy where he says he probably not gonna pick up, he on IG, letting these, and then there's a bad word, getting out of character. So clearly referencing this, conversation that is happening, and law enforcement is watching as well and recording that conversation that's happening on X.
Okay. And remind me, what was the day of the homicide? June
The June 23rd,
23rd. Okay, so this conversation is happening June 6th.
couple of weeks prior.
Okay, and so it involves, as we discussed, it involves Mr. Chance, or aspects of it involves Mr. Chance, Mr. Gathright, Mr. Rashad Murphy, but not Davion Murphy. I don't see him referenced in this interaction.
No, Your Honor.
Okay, so I guess my question to you is, would this be admissible against Davion Murphy, and if so, under what theory?
Because he also is a co-conspirator judge.
Okay, so you're saying this comes in via co-conspirator
Yes.
hearsay?
And Judge, with regard, and I know that, you had said that the conspiracy ends with the death. If, the state can provide, Your Honor, with any sort of case law having to do with flight after the crime.
Sure.
Would we, okay.
Yeah,
Thank you,
that's
Your Honor.
different, and it was, my comment was co-conspirator statements. Co-conspirator statements are inadmissible, my understanding, once the objective of the conspiracy is reached, okay?
Okay.
It's co-conspirator statements.